right. Good afternoon or morning, depending where you are. I am Trent Taylor, and I will be your host for today's quarterly webinar. Thank you so much for joining us. We have a great program today and a lot to cover. So we're going to jump in here pretty quick. As always, if you have any questions, feel free to ask them either here on the platform or via email or phone call later. We're always around to answer any questions you may have. I wanted to just introduce our lineup today. We have a superstar lineup. After a little bit of an intro from me, we're going to start with Katie Barber, who is one of our superstar appellate lawyers. She clerked for Justice Ruth Bader Ginsburg and will tell us about some of the SCOTUS cases that may affect you this term. I will then do a short bit on trends. Jenny Price will then handle product labeling, followed by, I believe, I will do some food labeling work after that. Royce, and here's the roadmap, Royce and Kate will handle regulatory. Jocelyn will handle NAD and alcohol. Frank will handle sales practices, and Talene will close us out with Prop 65. So that's sort of our lineup today. We're going to, real quick, I just wanted to mention what our theme here is. And I'll tell you, this is one of the favorite ones we do. For those who've been with us before, we do these roughly 4 times a year, and this is generally our favorite because it's some Halloween theme. And our theme today is Trick or Treat, one of our favorite times a year, and each of us are going to mention one of our favorite candies. But I did want to mention something else, and it's the dark side of trick-or-treating. Is there a dark side? And if you look at the actual history of trick-or-treating, it's really sort of fascinating because there actually was a time when like mischief and vandalism and crime around the Halloween area was a big problem. So they came up with this idea of doing organized trick-or-treating as sort of a way to bring order to the chaos and have a friendly bribe. But it made me question, is trick-or-treating innocent fun, or does it normalize extortion? And could you make an argument that today's plaintiffs' bar was emboldened by this trick-or-treating practice in their childhoods, leading to the current litigation environment? You can sort of imagine them, these plaintiffs' counsel, going up to knocking on doors and terrorizing their neighbors with thinly veiled threats of mischief in their youth. I'm sort of joking about that, but not completely. Anyway, those are questions to be answered another time. Here is my favorite candy, which is, we have this great shop here in Richmond called For Love of Chocolate, which has a ton of chocolate stuff, and it's very dangerous to go to. But I, go from time to time, and they have this, Lake Champlain 5-star bars caramel, which are delicious, and which I try not to eat very many of them, but on a few occasions a year, I will let myself do it. So that is my candy. And with that, I'm going to pass it off to Katie and ask Katie what her favorite candy is.
Thanks, Jen. I'd say my favorite candy would be a tie between Reese's Cups, but the mini Reese's Cups, because there's a more ideal ratio of chocolate to peanut butter there, or peanut butter M&Ms, because I do have a cousin who works at Mars and can get me fresh peanut butter M&Ms, or peanut M&Ms, sorry, not peanut butter, and they are actually far superior to even what you get in the store. So definitely a chocolate peanut butter person. So I am here to give you all the spooky Supreme Court update. A few cases that kind of have some potential impact in the food and product labeling space. So our first one, going in something of chronological order based on when these have been or are being argued, National Pork Producers v. Ross, which probably is the most directly food related, but with potentially much broader implications. So National Pork Producers deals with Proposition 12 from California, which is a law that bans the sale in California of any pork that was raised under cruel conditions. And defines cruel conditions to mean confinement in a pen that is smaller than 24 square feet. The problem being that most pork is raised in pens that are much smaller and raised in states outside of California. So Iowa and North Carolina, I think, being the main examples. California basically imports 99.9% of its pork. So this is a law that's going to have huge implications on the pork industry outside of California. So the question is, does this law violate the Dormant Commerce Clause, which is the kind of negative implication of the Interstate Commerce Clause? The Ninth Circuit said no, it doesn't, and you have the U.S. government coming in on the other side and siding with the pork producers, saying that it does. It'll be interesting to see what comes of this case, because the court has not taken up a lot of Dormant Commerce Clause cases in recent years, and this is something of a recurring theme for this term and for the cases today, that it's a little unclear what's going to happen because the composition of the court has changed so drastically in the past 5 years, the past 2 years. You've got multiple new justices who haven't really opined on some of these issues. So there is, some open question about what exactly will happen in a lot of these cases. The concern here, one interesting procedural aspect of this case is it was decided on a motion to dismiss. And so the pork producers' position is, you have to accept our allegations that the California law doesn't have any health or safety justification. It's really a morality law, saying Californians just have this a moral disagreement with inhumanely raised pork, and so that's really leads into the broader concerns of this case. If California can legislate on these kinds of morality grounds, what is the limiting principle on that? Are we going to end up in this kind of war of retaliation among the states, where red states are enacting certain kinds of morality legislation and blue states are responding with their own? The kind of lingering unspoken specter here is abortion, but also climate implications for state climate regulations, things like that. And you saw that in the questioning at oral argument, where Justice Kagan asked, well, if California could do this, could a law, back in the days of slavery, could a law be passed saying you can't sell products produced using slave labor? Justice Barrett asked kind of a different side of things of, could states ban products that are produced by companies that don't provide health insurance coverage for gender-affirming surgeries? So you can see how, for kind of both sides of the court, this case has implications that kind of cut both ways. I think the reporting on the argument after the fact was that the justices seemed flummoxed by the case. I think you're likely to see a narrow win for the pork producers here, but the court, the majority, is going to have to really walk a fine line to avoid kind of broader implications of how they come out here. Specific to the food and product labeling space, I think one argument here from the pork producers was California has a much more narrow solution to this. If they have this moral opposition to inhumanely raised pork, there's a simple solution: just require labels. And so labeling was discussed a lot at argument. I think if you listen to the argument, it's probably the most times that Whole Foods has been mentioned in an argument, because the debate, the discussion was, well, you're going to pay $8 for humanely raised pork at Whole Foods, or $5 for other pork at Walmart. So moving on to Axon Enterprise versus the Federal Trade Commission. So this is an interesting case about that kind of is tag teamed with a case about the SEC, about when entities that are subject to administrative enforcement actions can launch constitutional challenges to those administrative agencies in the federal district courts. So it's a question of whether the entity has to wait out the entire administrative adjudication and then sue and challenge the constitutionality of that proceeding, or whether they could sue and enjoin the proceeding on these constitutional grounds while it's ongoing. So in this case, you've got Axon Enterprise is a manufacturer of police equipment. They make body cameras and tasers for law enforcement, and they were acquiring a competitor. The FTC brought an administrative proceeding on and ultimately ordered Axon to undo the acquisition on antitrust grounds. Axon sued in federal district court, challenging both the nature of the proceedings, saying they violated Axon's Fifth Amendment due process rights because of the way that the FTC is structured. It's basically judge, jury, and executioner all in one. And then also raising separation of powers concerns because of the way that FTC commissioners are insulated from being fired. They can only be fired for good cause. So the district court dismissed the case for lack of jurisdiction and held that when Congress created the FTC, in the FTC Act, that Congress had impliedly stripped district courts of jurisdiction to hear these kinds of challenges before an administrative proceeding had ended. And the Ninth Circuit agreed with that dismissal. The court took up this question, but only took it up after there was a circuit split created in a different case that's going to be argued on the same day, which is Cochran versus SEC, dealing with basically the same issue, but in the SEC context. And courts had basically consistently up until now held that Congress did strip district courts of jurisdiction here, and the Fifth Circuit came out the other way in an en banc opinion in Cochran, and then the court took up both of the cases. So I think you're going to see here a court, with a lot of justices who are somewhat hostile, to put it mildly, towards the administrative state. And so, I mean, one factor is that the Axon asked the court to address both the question of whether district courts have jurisdiction, but also to address a broader question about whether the FTC's structure is unconstitutional, and the court did not take up that broader question. So this case is not going to entirely dismantle the FTC, but it, I think, likely will have some big implications for the way that FTC enforcement proceedings go, and whether parties who are subject to those types of proceedings can bring constitutional challenges earlier rather than having to wait for a proceeding to be fully resolved. And then the last case here, and this case is the reason for the RBG pumpkin on the slide. It's not totally a self-serving callback to my clerkship. But, this is Justice Ginsburg was something of a civil procedure nerd, and she authored the last real opinions on general personal jurisdiction, which is the issue that is raised in Mallory v. Norfolk Southern Railway. And so there again, we come back to the fact that the court has not addressed this question, hasn't addressed general personal jurisdiction in a while. Justice Ginsburg authored kind of the last two big opinions in that area, which are Daimler and Goodyear. Those were back in 2011, 2014. So you now have this newly composed court that hasn't really addressed this question in a while. And so it'll be interesting to see. This is another one where it's kind of uncertain what exactly the outcome will be. And I think however it's reached, you're going to see a lot of interesting and unusual combinations of justices and probably some fractured reasoning. So taking a step back, Mallory centers on this Pennsylvania law that provides that a foreign corporation that registers to do business in Pennsylvania is consenting to the exercise of general personal jurisdiction over that corporation in Pennsylvania. And so that means they can be sued in Pennsylvania for anything that happens anywhere, basically. So the broadest form of jurisdiction. And so the question is whether that law is a violation of the 14th Amendment due process clause. And the Pennsylvania Supreme Court held that it was unconstitutional under the international shoe line of personal jurisdiction precedents. I think probably it's hard to say what's going to happen here, but the Pennsylvania statute is somewhat unique in that there are a number of state laws that are like Pennsylvania's, but not as explicit in saying that registration constitutes consent. And so there are similar state laws, but a lot of them have been interpreted by the state high courts to not constitute automatic consent to jurisdiction. So even if the Pennsylvania law is upheld, that obviously would have broad implications for corporations that exercise, that operate across the 50 states. But at the same time, it could be kind of narrowly limited to the way that the Pennsylvania statute is written, which is somewhat unique. So that's one where it'll be, you saw some hints of how the court is thinking about jurisdiction in the Ford Motor case from, I think, last term or the term before, which was a specific personal jurisdiction case. But you got some hints there of how, you're definitely going to have some different ways of approaching this question, but not necessarily good hints at how exactly it's going to come out.
All right. Thank you so much, Katie. Really appreciate it. That was fantastic. I love hearing about the Supreme Court cases and that kind of thing. So thank you so much. I'm going to jump in now and talk about some trends that I typically do in this space, and we'll try to keep it short because I know we do have a lot to cover. I'm going to start with the numbers, and as y'all probably know, we keep track of all the class actions that are filed anywhere in the United States, and in this space, labeling, sales practices, that kind of thing. And it's a big job, but once we sort of get it together and whatnot, and we look at it, I almost feel like the Matrix, where you're looking at the numbers because you see all these things happening, and you're like, I see what's going on now. And we want to sort of let you in on what we're seeing. And so the first thing and the big takeaway is there have been 465 new labeling and sales practices class actions that have been filed since our last webinar, which is a ton and breaks all records that we've ever had when we've been tracking this. Now, it has been a longer period of time between webinars than we typically do for any number of reasons. But one of the things we do is we don't just rely on that. We actually adjust for the length of time. And even with that adjustment, we are still seeing a huge increase. And I think you see in the second bullet point there, it's a 47% increase from the last time we measured, adjusted for length of time. And the last time we measured was already a record. So it's just tremendous. And I keep thinking that at some point this has got to slow down, but it hasn't happened yet. And most of the growth was fueled by sales practice litigation, which is something Frank Talbot's going to talk about a little bit later on. That was up 122%. Product labeling was mostly static. It didn't really change very much, but there has been an increase in food and beverage and dietary supplement litigation, which rose 38%. Now, where are they being filed? I always like doing this because it's always interesting to me where plaintiff's counsel makes the decision to file these things. And you can see here that California is keen. There was a particular point in time when I think we were looking at New York and Illinois as sort of the new hotbeds for litigation. But right now, and those are still hot, but California Fed and California State are the big ones. And here are the actual raw numbers: 118 new class actions filed in California Federal. A little bit more in Northern District, but also a lot in the Central District. Also a lot in California State Court. And then you'll see some other ones here. The Illinois federal ones, that's largely Spencer Sheehan and some of the sales practice, the Mag Moss cases. Arkansas is almost entirely the Mag Moss cases, which we'll talk about here in a bit. And then you have a number of Florida federal cases, which is a lot of ingredient cases. It's a mixed bag, but Will Wright is sort of doing a lot of ingredient class actions there in Florida as well. Bottom line here is filings in California, Arkansas, and Florida are way up from the last time we measured. All right, who's filing the class actions? Probably not surprised to see Spencer Sheehan on here again. He had been down the last 2 quarterly webinars we had done, but he's now back up. He is leading the pack, closely followed by Bursar and Fisher and Pacific Trial Lawyers. Here are the actual numbers. Spencer Sheehan in particular, as I mentioned, he's up. He actually doubled the number of class actions he filed from the last time we measured, and that is adjusted for time. And what's really interesting is at one point in time, he was really focused on mostly vanilla cases and then maybe some other ingredient cases. And he still does some of the ingredient cases, but he also has expanded to other things, including sales practices, and even one public nuisance case against TikTok, if you can believe that. And then the other ones I wanted to mention, Pacific Trial Attorneys, they actually had like 3 or 4 new ones last night, which I couldn't actually include on here. So they have inched ahead of Bursar and Fisher to take the second place here. But Pacific Trial Attorneys, David Slade, Lynch Carpenter, and Nick Larry are almost entirely sales practices, and mostly Mag Moss, although Lynch Carpenter has done some other things as well. What are the claims that are targeted in these class action suits? Okay, so you'll probably see warranty as number 1 there. There have been a tremendous number targeting warranty, and that's not just Mag Moss, it's other things as well, but a lot of them are Mag Moss. Also falling under sales practices are hidden fee and auto renewal, but for product and food labeling type cases, you have ingredients, which is something that we've flagged before. You also have environmental and protein. And here are sort of the raw numbers on this. Under sales practices, I've already mentioned auto renewal and hidden fee, but there's also wiretapping, keystroke, session replay cases that Frank will talk about, and 15 on pricing issues, which is sort of an under the radar one. I mean, they've always been there, but there seems to be more of a concerted effort with those right now. And I think we will be talking a lot more about those on our next webinar. Lack of claimed ingredients, this is a significant increase from the last time we talked about it, mostly because Sheehan actually started filing cases again. Natural claims always hot, and you know, every time we do this, I'm always astounded that there's more natural cases, because I would have figured they would have all have already been done, but they haven't. There's more. And then chemicals, toxins, unsafe, a lot of those, 29. That was a big number as well. PFAS, titanium dioxide, benzene, hexane, salmonella, heavy metals, and others. We'll talk about that a little bit more later. Here are some of the other ones that wanted to briefly mention. Greenwashing, significant increase from the last time we measured. And a greater range of those. I mean, there are some of the sort of traditional greenwashing environmental claims, and certainly some of those, but we're seeing more of the next wave, the evolution, the next step in the greenwashing claims. And we'll talk about that here in a few minutes. Protein is a big one. There's several firms that are targeting the protein claims and have been for this year, but we continue to see those. Slackfill, I'm frankly astounded that Slackfill has risen back up, because there was a time when we were talking about, are we even going to have Slackfill class actions anymore? But here they are, 12, which is a huge increase. Now, a lot of those are with regard to dietary supplements, which we'll talk about here in a few moments. And one last thing I wanted to mention is private label products. That's something that there were 31 suits that targeted private label products, and those don't include the sales practices ones, which is a huge number, a huge increase. And in some cases, they were targeted even above the branded ones. And there's probably a variety of reasons for that. But if you're a retailer who sells private label products, you should probably be aware of this trend, because I think we're going to see a lot more of it going forward, where these plaintiffs' attorneys decide that they want to go after private label products. Here are the takeaways before I hand it over to Jenny to talk about product labeling issues. Here are the takeaways for the trends. Sales practice litigation, feeding frenzy right now, and I think it's only going to increase. And it's something that we all need to be paying very close attention to. Another record in filings, and you can see here, we already talked about ingredient claims are very hot. California is king. And then the last thing I want to mention real quick is just a tip. When you look at the chart, we are seeing the exact same plaintiffs filing suit in a lot of these cases. And sometimes it's even in different jurisdictions. And sometimes it's something where, you know, they'll wait 6 months or 9 months before they recycle the same plaintiff, but they do. And I think that's something that if you're in litigation, you can use that to your advantage once you get into discovery. And that's something that we've had some success with doing recruitment discovery. And if that's something you ever want to talk about, let us know, because we'll be happy to talk about it. So with that, I'm going to turn it over to Jenny. Jenny, do you want to tell us your favorite candy?
Thanks, Trent. I'm not quite as bougie as you are with your Lake Champlain candy, but I just go to the local CVS or Walmart and get, similar to Katie, Reese's Cups. But I like the holiday ones. So whether it's like the peanut, the pumpkin one, or the heart-shaped at Valentine's, those are my favorite. And I try to stock up on those during holiday times. So I'm glad to be with you all this afternoon talking about product labeling issues. Do you mind hitting the next slide, please, Trent? Thank you. So Trent and I were actually at a conference last week, and there was a ton of sessions on ESG. And ESG stands for environmental, social, and governance issues that come up. And the one that I'm going to highlight for you guys today is an environmental class action that was recently filed against Evian. And it's kind of hard to see on the Evian bottle. I didn't think it would be quite so difficult to see. I apologize for that. But the suit is over their carbon neutral bottles. So the claim is against Evian in the Southern District of New York, and it's a class action. The purported class is all similarly situated Evian buyers. And what the allegation is that Evian has been lying about being carbon neutral in order to mislead environmentally conscious customers into buying its water bottles. And that if this particular plaintiff had known that the company was not carbon neutral, then she would have saved her money and bought cheaper water, is the allegation. And there's some really interesting allegations within the complaint. I'm going to be very curious to see how Evian responds to the class action. But that is an example of another sort of environmental claims. Trent's talked a lot about the greenwashing. We've talked a lot about that for several years, and we've continued to see the greenwashing claims continue to be filed pretty aggressively. So this is just one of those examples of that. Thanks, Trent. Another really hot area in product labeling are the cosmetics and personal care space, and we've talked a lot about this in previous webinars, but two that jumped out between our last webinar and this one is the first is a New York class action, actually that was just recently trimmed down, and during the motion to dismiss, it was filed against Unilever over a Dove's Deep Moisture Body Washing, alleging that it was allegedly not being gentle. So that was a good move with a successful motion to dismiss there. The next one is L'Oreal. This was a suit that was recently filed, again in the Southern District of New York, and the allegation is that that L'Oreal misleads its consumers into thinking that its skin smoothing effects of the collagen products, mainly in this daily moisturizer, the collagen moisture filler, the collagen does not actually act as an anti-wrinkle ingredient. The claim is that the collagen particles are actually too big to be absorbed into the skin, and thus, be an anti-wrinkle ingredient. And the L'Oreal has filed a motion to dismiss on that consumer class action. So continuing to see a lot of cosmetics and personal care sort of all over the board with the different allegations on that, but all related to the labeling of those products. If you don't mind going to the next slide, please, Trent. So again, kind of sound like a broken record here talking about PFAS. We've been talking about this for a long time, but they continue to file suit, particularly in the consumer product area. For a long, long time, PFAS was really just in the fire retardant world, but now for the past, I would say, like year and a half, we've seen a big increase in PFAS litigation, both in the food labeling space and in the product labeling space. And there are two more consumer product PFAS cases. One is against Clorox and their subsidiary Burt's Bees regarding their mascara. And we've seen several mascara class actions. This is probably the sixth one that we've been tracking. But new to the PFAS arena is dental floss. So Procter & Gamble was recently sued in a class action alleging PFAS in dental floss. And then titanium dioxide, these continue to be class actions that are brought in the consumer space as well. There are 3 new tampon cases, and then one, this is the first time that the tampon cases with the titanium dioxide are not new. This is probably, gosh, the 7th or 8th tampon case, but new to the area is a Tylenol case against Johnson & Johnson. So we're tracking that as well.
Thanks, Jenny. I'm going to talk about a couple of additional ones here. And so 3 listed here: hydrogen peroxide, non-drowsy, and then max strength, extra strength. And I find it astounding that someone would actually file suit over hydrogen peroxide. And you can probably guess who has filed these suits. And if you guess Spencer Sheehan, you would be right. He's the one who has filed, I want to say it's like 6 or 7 against a private label hydrogen peroxide. And his theory is that it says you can use hydrogen peroxide to treat cuts, but that scientific studies do not actually support that, and that it's actually a folk remedy. So I don't know what's going to happen with those, but I thought those were interesting. And it shows that Spencer Sheehan will file suit literally against anything. Non-drowsy is another one that I think we talked about last time. It's essentially, the argument is that there's these non-drowsy cold remedies, that you take when you have a cold, and there's a non-drowsy version. And the allegation is that, well, it says non-drowsy, but it actually contains ingredients that scientific studies show can cause drowsiness. So there have been a number of these suits, and I want to say there were 7 additional ones since June 8th that were filed. The last one I wanted to mention real quick is max strength, extra strength. And a lot of these have been pain relief patches, which you see on the right here, but not just confined to that. It's been other things as well. And the central argument is that there's these products, and it'll say maximum strength or extra strength, but the plaintiffs are alleging that, well, actually, it's just like the regular version of the product. There's nothing different about it, and that the allegation is that they're putting maximum strength on there to charge a higher price and to dupe consumers into buying it and paying a higher price. So that's the allegation. There were 7 or 8 of those this past few months as well. And that's been Spencer Sheehan for at least some of those, but not just Spencer Sheehan. So those are the product labeling ones. I'm going to move right into some of the food and beverage and dietary supplements labeling litigation. And talk about some of them. But in the meantime, I saw some cute little Halloween food stuff that I clearly didn't make. I could never make anything that looks this good, but I thought they were cute nonetheless. Okay, so let's start with dietary supplements. supplements. And that's something that, we will reference from time to time in these webinars, but we generally don't spend a great deal of time on them, in part because we generally don't see a lot of class actions against them. I mean, there's always a few. And I want to say that the typical number is less than 10 new class actions from the last time we did this. As you can see, since the last time we did it, this time 36 new cases against dietary supplements. And that's probably a little on the low side because there's some that sort of straddle the line between dietary supplements and other things. So it's probably closer to 40. And that was surprising. And I think if you are in the dietary supplement business, you need to be aware of this renewed targeting of dietary supplements. Now, some of these are slack fill, and I think I mentioned that earlier. Others are attacking the product claims as false or not scientifically or clinically proven. Others, just go after whether it's natural or whether it contains artificial ingredients, which is, your garden variety claim. In particular, melatonin products have been targeted. I think, between 7 and 9 new class actions targeting melatonin products have been filed in the last few months, which I think has been interesting. Weight management products has been another one. Some of the Slim Fast products I know were targeted in several lawsuits, but there have been some other weight management products that have been targeted as well. And the bottom line is this. I know dietary supplements sometimes tend to fly under the radar, but not lately. They seem to be firmly in the crosshairs of plaintiff's counsel at this point in time. Okay, greenwashing. Now, those who have attended these webinars in the past know that this is one of my favorite topics, in part because I see it as the future of labeling class actions. And we always have some, but I've been a little surprised that sometimes we'll only have just a sprinkling of greenwashing claims. Haven't seen a lot. But as I mentioned earlier, we had a significant increase this past few months in greenwashing claims. And some of those are sort of your garden variety claims, the kind of claims that we've seen before, like the Dean v. Pete and Jerry's Organics free-range eggs. That's not something particularly new. We've seen those before. Also, the second bullet point, recycling bags, that has been something that has been around. Those recycling claims have been around for a while. Of course, here, this one is targeting a private label trash bags, great value for Walmart, which dovetails into what I was saying earlier about about private label products being the target. But there have been some other class actions in this space that have been filed that are sort of the next generation that have evolved. And one of those is at the top, targeting fair trade certified dairy products and alleging that the company's certification standards fall short of those protections. And, it's a little bit more in depth and nuanced than some of these other arguments that we've seen. So that one will be an interesting to watch. And then we have these two. And the Evian case that Jenny mentioned would fall into this category as well. It's for the next generation of greenwashing claims. And this first one is actually a Spencer Sheehan classic. And he's going after our airline and their claims to fly responsibly to create a more sustainable future, saying that there's no credible evidence that exists that it is actually carbon neutral. And then this last one I think is super interesting. And it's alleging that the defendant misled the public to believe that its manufacturing process was beneficial to the ecosystem, when in fact, allegedly, the defendant's practices have contributed to chronic overdraft of the aquifer. So I think you're going to see a lot more of cases along these lines in the future. And I think, that is something that we're going to be continuing to talk about. And we'll obviously watch these and report back on how they're doing. But the bottom line is, if you are making any type of green or environmental claim, you're going to want to make sure that you have substantiated it to the nth degree, and recognize that even with that, it's still probably going to be a target, and think through how you're going to respond and how you're going to defend against that lawsuit, because I think greenwashing is where we're going to see a lot more in the future. All right, ingredient claims. As I mentioned earlier, there's been a lot of those. I don't want to spend too much time on them. I think you're familiar with them to a certain degree, but I did want to show you sort of the latest iteration of these claims. They're going after berry, honey ingredients, fruit-based. The third one, lemon and honey. We've seen a lot of lemon and honey. In products being targeted, saying that they don't actually contain lemon, they don't actually contain honey. So that's one to keep in mind. Artificial flavoring, there's been a number of those as well. And then the Clif Bar one I think is interesting, targeting the advertised amount of caffeine. I've actually used that product, and I felt like there was plenty of caffeine in it, so I'm not real sure where this is coming from. In fact, I thought maybe it was too much caffeine. So that actually is a welcome sign. There's only, if that's true, there's only 1/3 the advertised amount of caffeine. But I think it's important to know that obviously caffeine is something that for certain consumers is important. It's a marketing tool, and we're starting to see some folks go after the amount of caffeine in products as well. All right, chemicals, toxins. This is something that Jenny touched on in the product space. We're seeing it in the food space as well. And there's been the PFAS cases, which Jenny mentioned, and there have been a number of them in the food realm as well, mostly with regard to food packaging, saying that a number of the fast food restaurants were sued. And I don't know if you've noticed, but I've noticed that some fast food restaurants have changed their packaging in terms of how they wrap the food, and it's now more paper-based as opposed to what you saw in the past. And I know a number of other fast foods are in the process of changing that for this reason, because there have been suits alleging that PFAS in the wrappers leach into the food, and it's something that causes consumers to ingest the PFAS. So there's been a number of those suits, but there have been others. Titanium dioxide, this was a relatively new one. They went after Skittles, and they've gone after some other products as well. And because it's new, and it's something that I know is in a number of products, I think we're going to want to watch that closely. I want to say there was maybe a total of 6 titanium dioxide cases over the last few months. And we will closely watch to see what happens with those. There's another PFAS case mentioned with regard to drinks, and then there's a hexane case that I wanted to note. The bottom line is this: as science has evolved to where you can detect even super minute amounts of certain chemicals and toxins, we're seeing more and more of these type of suits, and it just bounces around to what the toxin or chemical that is the boogeyman. What folks are talking about. And obviously PFAS is one of those, and titanium dioxide is maybe something that we'll see more of. So we'll keep a close eye on that. Other key trends, protein, as I mentioned, and obviously protein is a big selling point where consumers are looking for products that contain protein. And if you put 15 grams of protein, then if it's not that, then you have to worry that you may end up being sued. But there are some other sort of nuances and quirks of that we don't have time to get into in terms of what you can say. And even if you're being completely accurate in terms of what you're saying about your protein level, we still have seen a number of suits targeting that, especially when it's inconsistent with what is on the nutrition fact panel. So there have been plenty of those. There have also been calorie claims. I mentioned honey and lemon earlier. Total servings in a particular product. We've seen that in coffee. We've seen that in creamers. Those continue to be filed. I think they've slowed a little bit, but there's still been plenty of those. So there was maybe 11 of those over the last few months. And then cinnamon and peppermint claims were targeted as well just in the last few weeks. So we may see more of those going forward. I wanted to highlight a few key decisions that have come down over the last few months. I particularly like this first one, and not just because it came out of the Eastern District of Virginia, where we're located. It came down earlier this week, and it essentially related to the heavy metals in baby formula, baby food, with the allegation in those cases being, oh, I bought this product that we think it has heavy metals in some degree. It didn't hurt us, but we have been economically harmed by purchasing this product. And the court there said, nope, that's not enough. You have not alleged any injuries or damages. And that's great for a number of suits, because there's a lot of other suits out there that have a similar theory. And in fact, there's an entire MDL devoted to Family Dollar and a warehouse rodent infestation that has sort of a similar theory. No one's actually claiming that they ingested something that was contaminated, but because it could have been contaminated, they were injured. And this case, this judge said, no, that's not enough. So that's a really good decision for defendants in some of those other cases. Veggie burgers, finding that veggie does not mislead reasonable consumers into believing that the product is made primarily from vegetables. That was a little bit of a surprising one, but interesting nonetheless. And the one that is, I guess, a little ominous goes back to greenwashing. There was a case involving Gordon's tilapia products being sustainably sourced, and the court let at least part of that suit go forward. And we see a lot more of these greenwashing cases getting past the motion to dismiss, then that's going to be, that's only going to increase or accelerate the number of greenwashing claims that we see. Okay, a couple of other things real quick. Trial verdicts. We mentioned last time about this Premier Nutrition case, which had just happened. I wanted to update you on that because it's such, a big deal. We rarely see these cases in false advertising and deceptive trade practices go to trial. This is one that did, and the jury awarded $1.5 million in actual damages, and plaintiffs wanted to apply the statutory damages and get $141 million. There was a time there where we thought the judge would actually award that. He didn't in the end. So back in August, he awarded $12.9 million in statutory damages and interest. And I think the breakdown was maybe 8.5 in statutory damages, and the rest was interest. And that's obviously nothing to sniff about. And then the decision on attorney's fees is still pending. Plaintiffs' counsel has asked for $6.8 million. They're probably going to get close to that. I know Premier Nutrition said, no, it should be $3.5 million. The judge is like, no. So I think it's probably going to be closer to $6.8 million in the end. And then this last one is a Lanham Act case that was decided $293 million verdict in late September. So it's always good to keep in mind the Lanham Act, and that we're not just worried about class actions, we're worried about competitors suing us as well. Key settlements, here's two real quick. One, they're both over $10 million, which, is also nothing to sniff at. I mean, there was a time when, you expected these to be $2 to $3 million. Now we're seeing $10 million. And one involved recyclable, the other involved a health halo claim. The recyclable claim being a greenwashing claim in a result. $10 million settlement, greenwashing claim. So just wanted to briefly mention that. And then I don't have time to go into this, but there was one thing I wanted to flag. This is actually from a presentation I gave relatively recently. It gets way into the weeds, which I don't think we want to do here. If you want to talk about it offline, feel free to give me a call. We'll talk about it. But the main thing I wanted to mention is this, that the unlawful prong under the UCL in California, there is an effort by the plaintiff's bar to make that a strict liability claim. Essentially, that there doesn't need to be any reliance at all for that claim, which would mean that even if it's just a technical violation, you can still find a defendant liable without any of these reliance. So that's a fight that's going on right now that I think, we should all be paying very close attention to. And I put a summary of sort of where things stand right here. Sorry, go back one. And you can read the rest of the slides at your leisure a little bit later. But that's where things currently stand. And with that, I'm going to turn it over to Royce and Kate to talk about regulatory.
Thank you very much, Trent. This is Kate Hardy, and I have, Royce and I just have a couple quick regulatory updates for you. Real quickly, it must be something with the name because I'm aligned with Katie on my favorite candy. I love Reese's Peanut Buttercup, and I also love peanut butter and peanut M&Ms. So those are my faves. And just to give you all a quick update, I know CBD products are out there. They're everywhere. You see them in consumer products. You see them in pet products. We get lots of calls all the time, people saying, well, these must be fine because they're everywhere, which is generally not the case. It's very state specific. And just wanted to highlight, because there are a lot of CBD pet products out there, the state of Idaho put out a memo back in July basically saying they were going to start enforcing hemp in animal feed or animal products, and including, I think my camera just went away there, including CBD pet products as well that are sold in the state, and including anything sold kind of at the retail level. Enforcement is expected to begin November 1st. And we'll have to see how this plays out. But the reason we brought it up is if you have products that are being sold in the state, especially as animal food, you may want to pay attention to enforcement that's going on there. Okay, and then this measure is, it's being opposed. There's been a lot of press about it recently, but again, we'll have to see what happens. So for anybody who's selling or distributing any pet CBD products, you may want to look at what's going on in Idaho. It's also important to double check each state that you're in on a regular basis because this tends to change very frequently. And with that, I will turn it over to Royce. Actually, sorry, one other thing just to bring up. There is a thing on the Idaho website which seems to indicate that they may not enforce if you are selling a product with hemp or CBD that doesn't make any type of structure or function claims. So it doesn't claim to fix allergies or make any improvements to the pet in any way. That could be okay. It was a little unclear on the website, and we'll just have to see once enforcement starts taking place how that plays out. And with that, Royce, I will turn it over to you.
Awesome. Thanks, Kate. So I think my favorite candy is Sixlets, just because it brings back childhood memories of, stuff that you can just eat and is tiny and gives a great sugar rush. My second favorite candy is best described by the movie The Purge, which is candy corn. I think most people hate candy corn, but I like candy corn. And when they see candy corn, they just want to get rid of it. But I was always that kid that took candy corn out of people's Halloween bags. So, what's FDA been up to recently? I think I'm going to focus on some FDA issues and then focus also on some issues concerning cannabis to some extent. But, overall, we're seeing FDA really increase its enforcement of the foreign supplier verification program. That's your obligations as a company and industry to audit your foreign suppliers under the requirements under the Food Safety Modernization Act. And we have unfortunately seen FDA focus for reasons that are not really clear are companies that deal with products in Latin America and companies that obtain products from Latin America. So companies that are focused more on, obtaining products from Mexico or Costa Rica or El Salvador. And my suspicion is that FDA believes that there is an increased food safety issue from those countries, but I do think it is quite unique that when we're looking at foreign supplier verification program cases and warning letters, Latin America seems to be singled out more so than any time I've seen in the past. The other thing we've seen FDA do recently is release a guidance on N-acetyl L-cysteine. This is interesting. It's FDA kind of, I'm going to tell you why it's more interesting. Yes, it's great that FDA is giving some enforcement discretion to this dietary supplement, this dietary ingredient. You know, and that's cool. But what's more interesting is what this guidance means. And what it means is it's really FDA acquiescing to the power of the citizen petition is what I think. I think FDA got hit up by 2 citizens petitions from 2 very influential groups and realized that they really didn't have any good reason for denying this. But the even more interesting aspect of this guidance is that it's kind of, FDA has not said we're going to allow NAC at all times forever and ever as a dietary ingredient. They've come back in the guidance said we're going to exercise enforcement discretion. And that's because NAC is a lot like folic acid in that it's also a drug. So because it's a drug, it can't be a dietary ingredient as well. That kind of throws the FDA system into a system error, blue screen of death. But what FDA can do to get out of that is say, well, we're going to exercise enforcement discretion. So is this the secret code for how to get products that are having challenges loaded into the system to work? I don't know, but the guidance is really interesting. I think it slid under the radar, but I think it is, again, showing us a recipe for how to get creative and work with FDA to get things that may not make sense to make sense. So just leaving that to talk about, happy to dive more in depth into this and my views there. This is probably second favorite Halloween type movie is Big Trouble in Little China. I really like that one a lot, but that has nothing to do with LA. What's really interesting, and we're seeing, and Kate and I were just talking about this morning, is, you know, if you're out there and you're thinking about doing a deal in the cannabis space, licensure with cannabis companies or anything touching cannabis, we've seen a real increase in the Department of Justice's enforcement of pay-to-play schemes with respect to cannabis licensure, as well as DOJ's interest in illegal cannabis operations. The illegal cannabis operations are getting so good that they almost look as though they are real dispensaries and real wholesale distributors, except they're unlicensed. And then the scary trend that we're seeing is it has been alleged in jurisdictions like Nevada and Missouri and California that cannabis licenses were not obtained in the most ethical way possible, that there were pay-to-play schemes. I can't really opine on that. All I can say is that, you know, if you're doing deal diligence, doing licensure, partnership diligence, anything like that, look into and ask questions about how the cannabis licenses were obtained from whoever you are partnering with. This is more than just an aberration on DOJ's radar. It has been a real increase in DOJ activity. And I'm swapping over to my colleague Jocelyn now.
Thanks, Royce. So I am going to touch on a recent decision from the Better Business Bureau's National Advertising Division, NAD, and then also hit on 2 alcohol cases. But first, I'll talk about my favorite candy. When Trent asked us all to begin our slides with telling our favorite candy, I'm laughing watching this play out because only lawyers would state their favorite candy and then explain why it's their favorite candy, as almost all of us have done, and I am no different. So my favorite candy is Twizzlers, not to be confused with Red Vines, the lesser than wannabe Twizzlers in my mind. And so when I was creating this slide for you all, I wanted to give you the #1 reason why Twizzlers are better than red vines. And so I did some Googling, and y'all, I did not realize that this is a whole thing. Like the battle between Twizzlers and red vines, I mean, the articles I found were just hilarious. This is one of my favorites. This woman like researched and wrote specifically about the different shape and texture and flavor, comparing the two, and she ended it with, "Life will be sweeter when we end this thing once and for all." So, speaking of competing products, for those of you who have seen my slides before about the National Advertising Division matters, you know that those claims are almost always brought by a company's competitor. And this case is no different. So the first claim I'm talking about are claims that were brought challenged by Procter & Gamble Company, which is a maker of competing cleansing wipes for infants. And the product at issue here are water wipes, the world's purest baby wipes. And I'm not just calling them that as a mother, but that is no kidding like the line underneath the product. They advertise themselves as being the world's purest baby wipes. And so the National Advertising Division reviewed based on the claims that were challenged by Procter & Gamble and decided that some of the claims were supported and others should be discontinued. And so 2 of the ones that were supported are right here. Water wipes, baby wipes do not contain any chemicals or preservatives like other wet wipes, whereas other baby wipes contain up to 16 ingredients. Water wipes, baby wipes have just 2. And so the NAD said, okay, these 2 claims just simply underscore the advertiser's claimed benefit of its wipes. And the second one just distinguishes the number of ingredients in the wipes as compared to other competitors' wipes. So those are okay. They decided that those were properly limited and not falsely disparaging. But then the 2 that they asked them to discontinue, the first is water wipes, baby wipes don't contain the ingredients that can cause or exacerbate diaper rash. And water wipes are 99.9% water, which actually makes a huge difference because you can hide a lot of additional ingredients in 0.9%. And so when I read these, I took myself back to the early days of being a first-time mom and thought, oh my gosh, I have to use water wipes because all the other ones will cause diaper rash or exacerbate diaper rash. And what can they be hiding in this 0.9%? And so the NAD kind of thought the same thing. They said that these comments, these claims were expressly or impliedly conveying that the competing baby wipes with more ingredients can actually be harmful to your child and can cause or exacerbate diaper rash. And so for these claims, they said they were actually unsupported and asked them to be discontinued. 2 of the additional claims that actually were supported are this one. It says that we recommend that healthcare providers are aware of the ingredients contained in baby wipe products being used on the delicate skin of babies. Given the minimal ingredients and purity credentials of water wipes, they are an ideal choice. And they said that's fine, that it was supported in the context presented on the advertiser's website. And I was actually surprised about this one, but they supported the phrase world's purest baby wipes. And so it was supported in context because the context defined the message reasonably conveyed that water wipes are in fact the world's purest baby wipes. They contain 99.9% water and just a drop of fruit extract. And they say that that is to condition the skin and protect its integrity. So context was key here in supporting these 2 claims. And so that was the recent National Advertising Division matter that I wanted to share with you all. And now I just have 2 alcohol-related cases. Oh, and the response from water wipes was that they agreed to comply with NAD's recommendations, but they did respectfully disagree with some of the findings. Okay, the alcohol cases. The first one is out of the Western District of Missouri. Anheuser-Busch Ritas is actually a false advertising class action settlement. And the claim was just that its products don't actually contain tequila or wine or rum, but are actually flavored beer. And so the plaintiffs argued that they thought the sparkling margarita beverages actually contained tequila, that the mojito drinks were made with rum, and that the sangria and rosé Ritas actually contained wine. They argued that they had no reason to know and reasonable consumers wouldn't know that the products were falsely and deceptively packaged for those reasons, that it didn't state on any of the consumer-facing panels that the products do not actually contain distilled liquor or wine. And the plaintiffs argued that if they would have known that there wasn't distilled liquor or wine in the products, that they wouldn't have purchased them, or that they wouldn't have paid as much if they would have known that they were flavored beers. So Anheuser-Busch hasn't admitted any wrongdoing, but they did agree to the class action settlement, which also includes injunctive relief. So they've agreed to change its marketing to better inform the consumers of what type of alcohol is in the Rita's product, and the product packaging is now going to contain the phrase malt beverage just underneath where it says sparkling margarita. And the website also says the product does not contain distilled spirits. And so you can see it's very small, but that it now says malt beverage underneath sparkling margarita, and the website now says does not contain distilled spirits. And the final case that I want to share with you this afternoon is out of my home state of Colorado. Upslope LLC is a brewing company based in Boulder, Colorado, and they make a lot of different products and beers, but they have a specific line called Spiked Snow Melt. And their electrolyte series specifically, they advertise as having lower calorie, lower carbs and sugar, and being gluten-free. But it also says that the Custom Sport Hydration Drink Mix blend provides electrolytes and ascorbic acid, and that the Spiked Snow Melt drinks provide, quote, the perfect companion for health-conscious drinkers living the active outdoor lifestyle. So these plaintiffs allege that with that advertising, they thought these products were going to hydrate them, and that they were going to receive other benefits from the electrolytes and based on the nutrient content claim. So they said that they believe the drinks were unlawfully fortified and mislabeled, and they felt misled by it, and say, again, that they wouldn't have purchased the drinks or paid as much for them if they knew that they weren't going to actually hydrate them and they weren't going to receive health benefits from these alcoholic beverages. And the verbiage on the website has actually already changed. That last line right there now says, like the rest of the Spiked Snow Melt lineup, the electrolyte series is gluten-free. And that line used to say, the perfect companion for health-conscious drinkers living the active outdoor lifestyle. So some of that has already changed. So the key takeaways from my slides today are first, remember the overall context of the claim in your advertising. We learned that from the water wipes case. For the different claims that were supported, NAD said they were okay in the specific context in which they were advertised. Second big takeaway is just to consider how a consumer may interpret the advertising and include a disclosure or disclaimer on the label, like Anheuser-Busch ended up doing with their Rita's product. And my final takeaway is that Twizzlers are better than Red Vines. And with that, I'll turn it over to my colleague, I think Frank is going to discuss sales practices.
Thanks, Jocelyn. Hey everyone, I'm Frank Talbot, and I'll be talking about sales practices today. So first off, to start off with my favorite candy, it's king-size Reese's, not the small ones that you have to unwrap 50 of them to be satisfied, but just one giant king-size should do. And so we'll also start today with a slide. You can see on the slide the scene from Glengarry Glen Ross, where Alec Baldwin is instructing people to always be closing. And it's apt for the sales practices here because a lot of the topics and cases that we'll discuss is always about getting the sale and getting the consumer to purchase and get your product. So first we'll start off with the FTC and dark patterns. It's kind of spooky, as the title would imply, dark patterns. Dark patterns have been defined as generally deceptive practices that affect user experiences and kind of trap the consumer into making a purchase or making a decision that he or she wouldn't otherwise already make. And as you see in this slide, it's the header from a staff report at the FTC called "Bringing Dark Patterns to Light." The whole report is an update from April of 2021, where the FTC put on a workshop called "Bringing Dark Patterns to Light," where they highlighted unscrupulous practices by retailers and other businesses, and it was I think a half or full day seminar they put on, and they've since updated it to account for the last year and a half of alleged dark practices and dark patterns in litigation. And I think what the key thing about the dark patterns, though, is it's primarily in the online space. We have moved in and kind of more quickly since 2020 into an online world where consumers are getting and consuming online a lot more than they would from a brick and mortar store. So as we talk about some of these, you can see the brick and mortar analog with like pricing and signing up and trapping consumers into subscriptions. It's going to be more online now versus in person. So related to that, and keeping with the trick or treat theme, I often wonder if FTC would mean first to candy in the trick or treat line, because what we see frequently is the FTC is taking enforcement actions or announcing investigations or settlements, and then shortly thereafter, enterprising plaintiffs' attorneys file class actions. The Kochava data sharing, the first one listed there, I'll note the FTC filed its suit at the end of August this year, alleging various practices were about sharing geolocation data of consumers violated FTC regulations, and then less than 2 weeks later, there's a consumer class action that basically alleges the same exact thing. TikTok was hit with a similar situation a year or two ago, and FTC announces its action, and suddenly there's a consumer class action. Fashion Nova dealt with suppression of 1-star and 1-star through 3-star reviews. FTC said, hey, if you get a 1-star review, you can't subject it to review and only automatically post 4- and 5-star reviews. But, then a couple weeks later, consumer class action alleging the same thing. And then even if it's not exactly following on to an FTC action, a lot of these new sales practices, litigations reference the FTC, the FTC's involvement, the FTC's deeming of certain practices as deceptive or unlawful. And so those are usually included in sort of the background information from some of these complaints. And so while we're not necessarily going to discuss in depth any of the FTC actions today, I highlighted it as sort of a precursor. If you're getting an inquiry from the FTC or the FTC's knocking at your door asking trick or treat, then don't be surprised if standing right behind the FTC is a plaintiff's attorney asking for the same thing. So the first sort of set of sales practice class actions I wanted to highlight are the session replay and wiretapping class actions. And they are very similar in they essentially offer third parties insight into the user experience on a website. So the session replay allegations are recording your basically every move on the website, so that data can be compiled and sent to whatever third parties, and those third parties can run their analytics and decide how they want to advertise and target you and that as well. The wiretapping is similar, but the wiretapping class actions that we've seen so far in the past couple of weeks have been specific to the chat function of websites. So you log onto a website and a bot says, hey, can I help you? What are you looking for? And the allegations there are that these chat bots are then allowing these third parties in to follow what you're saying so that they can get a read on your user experience and again, use that to hand off to third parties for their own data analytics. In terms of who's bringing these, Trent highlighted that Lynch Carpenter had started bringing a lot of these, and also that Pacific Trial Attorneys had as well. Lynch Carpenter appears to be doing the session replay ones, and those have been heavy in Pennsylvania federal court. That's where their main base is located, as I understand it. And companies such as GameStop, Zillow, Cabela's, True Value have been hit with these, and even for the food and beverage space, for our furry friends, Chewy has been hit with the session replay suit as well. In terms of the wiretapping, we've seen a lot of those coming from the Pacific Trial Attorneys outfit out in California. And as Trent mentioned, there were a slew that came in last night, and a slew of their class actions came in last night, and it's the wiretapping. And the second bullet point there, single individual, multiple websites, Miss Valenzuela has, through Pacific Trial Attorneys, brought about, as I could count, I think 5 or 6 of these wiretapping lawsuits already. The pattern seems to be somewhat like ADA compliance for websites, where you have a blind person using a screen reader, and the individual plaintiff is hitting a bunch of different websites sort of at once. And so, again, it seems like the wiretapping allegations, at least, are following that pattern. The session replay, I've seen a couple of plaintiffs hit multiple websites, but not like the wiretapping allegations. And so then, just in terms of relief that they're seeking, it's injunctive relief and statutory damages. The wiretapping, there's a California statute and a similar Pennsylvania statute that allow for injunctive relief and statutory damages. So all of those have just been filed recently. There have not been any motions to dismiss decided that we have seen. There have been some filings that indicate that a motion to dismiss is coming, but no real substantive development on any of those yet. But those have exploded in the past 3 months-ish. So the second set that we're seeing is a lot of auto-renewal class actions. And what these do is they seek to lock in the consumers and sort of have the long-term monthly subscription follow on with payments. And so the general allegations here are that you get a free trial. So for HelloFresh and Instacart in the food and beverage space have been hit with these. The allegation is, hey, consumer, sign up for this free 30-day trial. Like, enter your payment, but you're not going to be charged, and you can cancel anytime. I'm sure a lot of us have a lot of familiarity with it. But these class actions, then you get your free trial, and then the consumer doesn't say anything back. And so the company, plaintiffs' attorneys are alleging that the consumers want to get out of these things. They really just want the 30-day free trial, and they want it to end there. But, for us, it's like, if I sign up for something and I like it, I'm not going, and I know that I'm going to start paying for it after my free trial, I'm not necessarily going to go to the company and say, hey, I really like my free trial, continue to charge me. I'm just going to continue to be charged for the service that I like and receiving benefit from. So the rub comes for these class actions where the plaintiffs allege that they've tried to get out, and to unsubscribe, you've got to go through 7, 8, 9 steps, and you just can't get out of it. And so, again, you're trapping the consumer. That's the dark practice. Next, we have what I would call price trick class actions, phantom pricing and hidden fees. The false reference prices are where a company is listing a discounted price, and then you go to your cart and you say, hey, that's not what the price said. Think of brick and mortar like it's on the shelf saying one price, and then you're being charged a different price. We have a couple class actions related to price freezing, where you're prompted with a website saying, oh, only 5 left at this price, or only like get it now, or in 5 minutes the price goes on. And then there have also been a couple of allegations against companies that are using influencers to unlawfully inflate their prices. Scott Disick and Miss Kardashian West are 2 defendants in one right now. A lot of those are out in California. And then hidden fees, we have Grubhub, and then other grocers who have been hit with class action fees or class action allegations related to in-store pickup. People wanting to order online and go in, and then they've got a $2 charge for in-store pickup, but that was never disclosed. And then you have Grubhub and other food delivery services where you put it in your cart at $10 and then it's $25 by the time it gets to your door. Then Trent is going to touch on Magnuson Moss real quickly.
Yeah, I'm going to hit it real quick, and then we're going to wrap up and throw it to Chalene for Prop 65. So Mag Moss, this is something we could spend an entire hour talking about. We're not. Here's just the basics of it. There have been 47 class actions filed based on the Mag Moss Warranty Act alone, meaning there's no other cause of action. It's just Mag Moss. And they have been filed since June. There's 2 theories. One is against manufacturers, one is against retailers. The claim against retailers is that they have violated the pre-sale availability rule by not making warranties available to consumers prior to purchase. They want warranties to be either posted next to the product, which seems like it would be impractical, to be polite, or they want to have something that says, go see the store manager and he'll give you the warranty. For manufacturers, plaintiffs are claiming the content of the warranties violate the act due to unlawful tying, the use of certain brands of parts and specific repair entities, forcing consumers to use those rather than a third parties. As I mentioned, 47 total cases have been filed. 25 of those are against retailers, the remaining against manufacturers. 24 are in federal. They've all been filed in state court. I think there have been 23 or 24 of them that have been removed thus far. And they are in Arkansas, Illinois, Pennsylvania, and California. So we'll keep a close eye on those, but that's what it is in a nutshell. Frank, back to you.
And just real quick with the sort of forecasting the future for some of these recently filed practices, class actions. Some of the earlier filed ones were voluntarily dismissed, suggesting that the homeowner just wanted to give the treat and get the plaintiff's attorneys away. Others have been sent to arbitration based on terms and conditions and consumer agreements that mandated arbitration and mandated individual actions and no class, and suggesting that they hit the house on the block that was giving away fruit, leaving unsatisfied. And then others survived motion to dismiss, and you're having to go through the haunted house of discovery, and it's to be determined whether or not ultimately plaintiffs' attorneys will be able to roll the houses or whether they'll get treats or tricks at the end of the day. With that, I pass it over to Talene.
Hi, everyone. I'm going to be presenting on Proposition 65, but first I'd like to tell you a little bit about my favorite childhood candy. Could you click to the next slide, please? And that would be Nerds. So a fun fact, both of my parents were dentists, and as a result, much like Prop 65, my parents heavily regulated our sugar intake. In fact, my house was kind of like the house that gave out fruit, except my parents gave out toothbrushes. As a result, we were on the receiving end of more tricks than treats. But my sister and I would stockpile nerds that we collected while trick-or-treating for the rest of the year. And much like the nerds themselves, the most recent Prop 65 California Court of Appeal case is pretty sweet for defendants. Next slide, please. So the case that I'm going to talk about is Environmental Health Advocates, Inc. versus Stream, Inc. It's also known as the California water bond case, which will be very clear in just a second. So on September 26, 2022, the California Court of Appeal delivered its opinion affirming the trial court's ruling granting defendants judgment on the pleadings and dismissing the action with prejudice. By way of background, plaintiff in the Stream matter brought its Proposition 65 claim against a water pipe manufacturer. A water pipe, otherwise known as a bong, typically consists of a chamber that contains water and a mounted bowl where the user may burn a particular substance. And then the water pipe, if used with marijuana, produces marijuana smoke. And marijuana is a Proposition 65 regulated carcinogen. Next slide, please. In affirming the trial court's ruling, the Court of Appeal relied, the previous slide, please. So the court's reasoning was as follows. First, the court basically explained that water pipes are not always used with marijuana, and forcing the water bong manufacturer to place a warning on its product simply because it could be possibly used with marijuana to create marijuana smoke would create confusion. Thus, the court found that the introduction of this confusion would not advance the purposes of Prop 65, and so the warning should not be placed. Secondly, the court concluded that the reasonable foreseeable use element could not apply to the term expose because there's nothing to indicate that there is direct exposure from use of the water bong unless you decide to actually put marijuana or another substance in it. Next slide, please. The court also distinguished between products that actually contain the regulated substance or chemical versus those that can be used to create that regulated substance or chemical. In this particular instance, use of a water bong without any additional substance included would not create marijuana smoke and thus no regulated substance. And this is distinguishable from those products that may contain a substance that Proposition 65 seeks to regulate, either naturally or through their manufacture. Finally, the court concluded that water pipes are not passive vessels. However, they are still entitled to the passive vessel treatment, and that any chemical exposure they cause is indirect and the result of the consumer's decision about how to use the product. Without direct exposure, there's no duty to warn. Last slide, please. So this case has a clear impact on the current litigation that's going on in California regarding acrylamide and air fryers. It's very easy to draw the analogy between a water bong and an air fryer. First, not all foods that are cooked in the air fryer will generate acrylamide. The creation of acrylamide depends on the food the consumer chooses to cook in their air fryer, much like the material that a person may choose to put into a water pipe. And finally, like the water pipes in the Stream case, air fryers do not contain the alleged chemical, and so there's no reason to provide a warning for these products, given the fact that they do not contain acrylamide in their manufacture. And then I'm going to pass it back to Trent.
Thank you so much, Colleen. That was a great job in a short amount of time. So thanks a lot. And thanks to all our panelists who did a fantastic job, a lot of interesting stuff. I will close this out with two things. Number one, I know there was a question or two about COEs. I know that we endeavor to get COE credit. I don't know exactly what the process is. but we will send out an email to attendees sort of letting them know what they need to do, if anything, to obtain COE credit. The second thing I'll mention, as always, is thank you so much for attending. Really appreciate it. And if you have questions, comments, or ever want to talk about any of these issues, you can always feel free to email or call us. Like I've said before, we love talking about this stuff and thinking about it. And as I said before, thanks so much for attending. Have a good rest of the day.